Okay. Well, we got new equipment and didn't know how to work it, so. Court does call the case people versus Brandon G.
And was it on behalf of the people, Your Honor?
Assistant Public Defender Ben Dunawith on behalf of Mr. Gevers, who is standing to my right. Brandon, would you state your name for the record, please?
Brandon Gevers.
Your Honor. Yes, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30, Judge Slay.
Your Honor, could I address Braun briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to take it off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the court's discretion, but I just have concerns given the highly valued factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
At all. It's just a GPS location track.
I would ask the court, if we don't leave the tether on until tomorrow, she is in state today. So I would have concerns for her safety while she's here, and ask if the tether be moved tomorrow when she's back out of state.
Right. His bond will continue. What I will do is I've sent an order. We'll remove the GPS tether effective Friday.
Yes, sir.
Okay.
Thank you.
Thank you, Judge.
Yes, sir.
Thank you.
Court does call the case people versus Sierra McCoy Nobles.
Good morning, Your Honor. Edward Drukes on behalf of Sierra McCoy Nobles.
Your name, ma'am?
Yeah, McCoy Nobles.
Thank you. This is a waiver.
That's correct, Your Honor.
Ma'am, you're waiving your right to a preliminary examination?
Yes,
And you understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
yes,
You understand you'll not have that here. You'll proceed to circuit court for further resolution.
yes,
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, and 3 with 4 following. Mr. Jurgens.
Your Honor, we acknowledge receipt of the information, stand mute, waive reading, and ask for a pretrial date.
Defendant having waived formal reading, standing mute to all 4 counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30 before Judge Slay.
Thank you, Your Honor.
Bond will continue. The cases of the people versus Brandon Carter. Didn't mean to wake you. No.
Lauren Brown, Deputy Chief Public Defender King, on behalf of Mr. Brandon Carter. It has been discovered that Mr. Carter has been lodged at the Monroe County Jail.
Oh,
But he is unable to make this court date. He'd love to, but
so he's currently lodged there?
that is my understanding.
Is that also the people's understanding?
My officer in charge.
Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't.
All right, well, why don't I do this then? I'll find good cause adjourn the preliminary examination. I can set it for the 3rd or the 24th of June, which would 24th. June 24th, 2025.
You don't have.
Then this is all messed up. Why? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of,
Yes, of June, because it's Juneteenth. So it's PM.
oh,
Hang on, okay.
June 17th, 2025 at 12 noon.
Your Honor, would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date? Obviously, we will work to rid him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond. Your Honor. Like $10.
Brown, when have you ever known me to set a $10 bond? I think I did once. Still haven't seen that person. I'll set bond in both cases at 1,010%.
Thank you, Your Honor.
Thank you. Versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
Good morning, man. Please, Honorable Court, Kareem Johnson, appearing on behalf of Mr. Buckner, approaching and seated to my right.
State your name, sir. Thank you. All right. Date and time set for preliminary examination. You may proceed.
That's correct, Your Honor. The people are ready to proceed. We intend on calling one witness, and the people call their first witness.
You may.
We would call Amy Hudson to the stand.
See on the phone again. See on his phone or no? Because you did that at the. Pardon? Council approach, please. Yeah, have her sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God? See, state and spell your first and last name for the record.
My name is Amy, it's Amee, my last name is Hudson, ASO.
All right, you may inquire.
Thank you, Your Honor. And just one other matter. My officer in charge, Deputy Von Heath, is present in the courtroom. He's the only other witness I have present. I don't intend to call him, but he is present.
All right, good.
Miss Hudson, directing your attention back to the date of April the 1st of this year, 2025, were you in this courthouse testifying in a preliminary examination on a different matter?
Yes,
Okay. And was that in this very courtroom, courtroom C?
yes.
Okay. And who was the judge at the time? Judge Washington? Okay. And was the defendant in that case, based on your understanding, Ms. Hudson, Mr. Buckner?
Yes,
Is he present in the courtroom here today?
yes.
Can you identify an article of clothing that he's wearing?
He was wearing a black.
Okay. Your Honor, may the record reflect in-court identification of the defendant?
Without objection, record shall so reflect.
And I don't want to get into the facts of that case, but you were some sort of witness in that criminal case. Was that a criminal case?
Yes,
Okay. And you were a witness in it?
yes.
Okay. And had you testified before Judge Washington in that matter on the date of April 1st, 2025?
Yes,
Okay. At some point, were you done testifying?
yes.
Okay. After you were done testifying, what did you do?
I went and sat back down while they called up the next witness.
Okay. Where did you sit down?
I sat about where I was sitting when I stood up today, maybe one row up.
Okay. So we're making a transcription of this. So I'm going to have to be.
It's on the right-hand side, probably in the third row back.
You're pointing in the courtroom. So you remained in the courtroom?
Yes, I remained in.
Okay. So you sat down in what we would call the gallery of the courtroom from where you are sitting in the witness stand on the right-hand side. And you said about the third row back.
Third row back.
Okay. And you did that while another witness was testifying? Okay. And at some point in time, did that witness stop testifying?
Yes.
Okay, what happened after that witness stopped testifying?
The judge asked for some more information and then she called for a break.
Okay. The judge stood up to take a break? Okay, is that a yes?
Yes.
Thank you.
I'm sorry.
It's okay. And what happened when the judge stood up to take a break?
When they called the court for recess, he was on the left-hand side.
Who is he?
Mr. Buckner was on the left-hand side. He stood up. He was around two people that had already started to be in the row.
I'm gonna just stop you right there. So you've said the left-hand side, that would be the left-hand side of the courtroom from where you are seated in the witness stand today?
Yes.
Okay. That would be the side that the defendants normally sit at?
Yes.
Okay. Where was the defendant seated?
He was in the first row back.
In the gallery?
In the gallery.
Okay, so he was not seated at council table?
No.
Okay. So the judge, the judge got off the bench and exited the courtroom?
Yes.
Okay.
Yeah, the judge, she did not exit the courtroom right away. She stood up, as they were calling. There was two people up front talking to her. And then when she got done speaking to them, that's when they called the recess. And he stood up.
He being the defendant?
The defendant, yeah. Went towards the middle. There was two people already going to go to exit. He waited until the sound went out.
Okay, when you say how do you know he waited until the sound went out?
Because he turned around and he looked. He stopped.
Objection, speculation.
I'm gonna overrule the objection. I'm gonna let her.
He stopped. He looked back. The minute
Hold on, look back at
at the
where?
screen, he looked back at the screen to make sure that the judge.
I'm gonna just,
Okay.
I'll stop you there. We're gonna unpack this a little bit. And Judge, I understand the court's
Okay.
concern. So you observed the defendant. You said he stopped. Where did he physically stop?
In the middle.
In the middle aisle?
In the middle of the aisle.
Okay.
Yeah.
Where was he in the middle of the aisle, close to what we would call the bar or close to the back door of the court?
He was in the middle, like closer towards this side of the court,
You're motioning the right side.
the right side.
Okay,
Yes.
but I'm asking you, distance wise, was he in this area or was he in the back part of the
No, he was closer towards the
front? Okay. You are still, fair to say, you are still seated in the third row
still seated.
on the right, your right side of the courtroom.
Yes.
Okay. When the defendant stopped, is he looking at you or is he looking somewhere else?
When he first stopped, he was looking like straight ahead.
Straight ahead.
And then he
And-
turned
Straight ahead toward,
Yeah,
towards the exit door.
towards the exit door.
Yes.
Okay.
And then when he stopped, he turned around and he looked.
And in what direction, when he turns around and looks, in what direction is he looking?
He's looking to see if the judge is.
I'm not, and so I'm not asking you. You can testify to things that you see, things that you hear, things that you witness. You can't testify to what someone else is thinking.
Right.
Okay,
No, he
so,
turned in the direction as to where the judge stand is.
okay, so just so we're clear, the defendant was looking towards the back doors of the courtroom. He then turned around and is looking in the direction of where the bench and the TVs are.
Yes.
Okay,
Yes, the bench and the TVs are.
at some point, does he then turn back around to look towards the back door?
Yes, he does.
When did he do that?
The minute the screen started making that sound.
Like a white noise sound?
Yes.
Okay.
Yeah, like
And
it's no longer.
And I will direct your attention right
Okay, go ahead.
I'll direct your attention. Right now, there are screens on in this courtroom. You see those?
Yes,
And they're depicting the court and yourself in the witness stand. Is that correct?
yes.
Okay. Did the screens look like that when the
No.
okay. What did they look like if
They
you look?
were like, as if the cable went out, they were, there was nothing there. It said private.
Okay, it said private.
There's a black screen with private written in white.
Yeah,
Okay.
yes.
At that point, once the screens changed from showing the video of the courtroom to this private, what did the defendant do?
He walked on to the right-hand side, stopped to where I was sitting and, made verbal threats.
Okay, he said something to you?
Yes,
What did he say to you?
he called me,
I'm gonna stop you right there.
yes,
Hold on a moment. You mentioned something and I just need to clarify this. You said that there was static.
yes, sir.
What was that you're talking about?
There was no more pictures showing. It was just a like when you call up the lawyers to speak to you, the screen makes a noise. It makes it makes a noise. I don't know how to describe it. It's not it's not a silent noise. It makes a noise to where it's not recording anymore. Do you want me to sit down so you can turn it off?
No,
Okay.
pretty much here every day. I'm just trying to figure out what you're talking about. You're saying it made a noise.
Yes, the screen went blank. And it's not like it's crushing out a noise, there's a noise.
Coming out of the speakers.
Yes, coming out of the speakers.
Was it a constant noise?
It started, and then I'll be honest, I don't know if it was coming on.
Gotcha. Okay, just one other thing.
That's fine.
When you said Judge Washington was talking to two people, was she talking to two people in front of the bench or two
Yes.
people behind the bench?
No, two people in front.
So she was speaking to two people in front of the bench. All right. At the point at which she's doing that, can you hear that conversation?
No,
Okay, at the point at which she's doing that, do you hear anything in the courtroom?
no. I mean, I can hear people talk, but not up front. I mean, just what, people may be saying as they're sitting on the gallery.
Right, but do you hear anything else?
No,
Okay. And she had that conversation and turned around and left.
yes, yep, they call.
At the point that that happened, what was on the screen?
Before, when she got done speaking to them,
Not as she's talking to them. What's on the screen?
there's nothing on the screen.
All
And
right.
then she got done speaking, and the video came back up before they called recess.
And when you say the video came back up, the video like it is right now?
Yes, and it
Okay.
just showed her on the bench. There was no one on the stand.
Okay, go ahead.
So at some point, as we've discussed, the defendant then turns and is walking, now facing back towards the back door,
Yes.
which would also be in the direction that you are in relation to the defendant.
I think he's just recapping what she's saying, so I'll overrule that. Go ahead.
Yes,
Okay. And you had previously said the defendant said something to you.
yes.
Okay. What did he say to you?
He called me a lying bitch and told me that that he was gonna get even, he was gonna get me. That was the last thing he did. He was gonna get me.
Did you say anything in response to that?
No,
How did that statement by the defendant make you feel?
correct.
After he made that statement to you, where did the defendant go?
He turned around, looked back one more time.
I'm going to stop you there just so we're clear. So at the time he's talking to you, is the defendant looking towards the back of the courtroom or the front of the?
He's looking towards, well, he's looking at me.
Right.
At the exit.
Okay, so he's facing away from where the judge would sit.
Yes.
Okay. After he makes that statement, you said he turns around?
Yes.
Okay. When he turns around, in what direction is he now facing?
He's facing back towards the front where the judge would be sitting for
Okay.
this area.
At the time he turns around, is the judge on the bench?
No,
Okay. If you recall, at the time he turns around, who would be on, and I'm motioning on the other side of the bar, who were there attorneys or people present?
yes, yeah,
Okay.
his lawyer was still on the left-hand side. You guys are still on the right-hand side.
You guys being someone from the prosecutor's office?
Prosecuting,
Okay.
yes. And there was one officer also on the right-hand side, and there was one officer sitting out in the galley, like 2 up from me.
Okay. So the defendant makes a statement to you, he turns around and he's now facing back in the direction of where the judge would sit, and what happens next?
The minute he saw that his lawyer was coming out, he turned around and took out the exit door.
Okay.
So again, speculation of what my client saw.
Okay. I would agree. So
Let me ask-
his lawyer, what you saw, ma'am, was his lawyer starting to leave and then he left.
Yeah. The minute
That's
he
what you, no, that's what you saw.
Yes,
Okay, thank you. I think that corrects it. That's right.
Go
ahead.
And did you remain seated in the gallery of the courtroom, or did you exit the courtroom at that point?
I remained seated.
Okay. And at some point after this fact, did you bring what had happened to someone else's attention?
Yes,
And who was
it
that?
was one of the police officers.
One of the police officers present in the courtroom?
Yes.
Okay. After you made contact with the police officer, did you have any further interactions with the defendant, Mr. Buckner? Okay. Certainly not in the courtroom,
Right,
correct?
right.
Okay. Anything in the hallway of the courthouse?
No,
Okay.
no.
Mayor, one moment, Your Honor.
You may. While you do that, ma'am, you said you were seated in the third row. How far in on that third row were you?
Right there where the gentleman is with the black sweatshirt.
So you were seated on the end
Yes.
toward the aisle.
Yes.
Okay.
I have no further questions, Judge. Thank you.
Cross-examination.
Okay, ma'am, so you were here to testify, and if you remember, was that in case number 25 FB 1106, if you know?
I have no idea.
Did you get a subpoena to come to court and testify in that
No.
case? In that case?
I did not get a subpoena.
Okay.
They asked me to come and testify.
Now, it's my understanding that you're indicating that you are
Picking
sitting
him up. Picking him up.
in the gallery of the courtroom right here.
Wow. Okay, yeah, gotcha.
Is that correct?
Yes.
And you said that there's a member of law enforcement 2 rows up, sitting right here, where there's an individual with a sheriff's shirt.
Yes.
And your testimony to Mr. Buckner comes down the hall, the aisleway, stands at that same pew where the law enforcement officer was, and issues a threat to you, which would have been within 15 feet of the law enforcement officer.
I never said that. I said he stopped at where I was sitting and said something to me. I never at any time said anything that he stopped where the police officer was sitting at the pew.
So when he stopped, he was at your row,
Yes,
Picking him up.
but there was still a law enforcement officer 2 rows up.
yes.
Was there other law enforcement officers in the courtroom like there are today?
There's one sitting up in the corner, up here on the right-hand side, where the gentleman is with the glasses.
When any of, I'm sorry,
Sitting where?
The gentleman with the glasses over here,
Mr. Bird?
yes, that's where the other.
Oh,
officer
on this side? On
Yes.
this side?
On this side.
On the right? Okay,
Yes.
go ahead. Go ahead, counsel.
when this statement was allegedly made, none of the law enforcement officers in the courtroom jumped up and said anything?
No,
Now, you indicated that after you testified, you stayed in the courtroom.
yes,
was there a sequestration order that, was there an order that you leave the courtroom after you finish testifying?
No,
Okay, so you heard the testimony after your testimony.
yes,
Mr. Buckner's lawyer at the time challenged the accusations that you made regarding Mr. Buckner, correct?
Your Honor,
In which case?
In the case you were there to testify about.
Your Honor, I would object to what that other lawyer did. That would be hearsay.
I'm not asking for
Well,
what,
she's asking, I'll overrule that. I mean, he's not asking what she said. He's just asking what her impression of what he did.
right.
So go.
His lawyer in the case you were there to testify on was challenging you on the assertions, allegations you made about Mr. Buckner.
for that case?
Yes.
Well, I mean, I don't know if he was challenging me, he was just questioning me, the
Okay.
same as you are.
And there was another witness that came up to testify after your testimony, correct?
Yes,
You heard that witness's testimony.
yes,
You were there when the preliminary examination ended, correct?
yes,
That Judge Washington, found that there was no probable cause that Mr. Buckner committed a crime. Correct.
I would object to the relevance of that.
Well, Your Honor, the relevance is they've charged my client with intimidating.
I'm gonna overrule the objection.
Yep.
Go ahead.
Judge Washington found that there was no probable cause to believe that Mr. Buckner committed a crime after you testified, correct?
she also stated that it can be called back up if they get the proof that they need.
Okay, which is fair. All right. So after you made accusations about Mr. Buckner pointing guns at people, correct?
What does that have to do with this case?
Ma'am, I don't,
Answer the question, ma'am.
Yes, I did.
you made accusations that you saw him deliver crack from a great distance away? You didn't make the accusation? Did you make an accusation that you saw him point a gun at somebody?
Yes.
Okay. No further questions, y'all.
Anything?
I have no redirect, Judge. Thank you.
All right, ma'am. How long did it take you to report this to somebody?
Within minutes.
Where was Mr. Buckner when you reported this?
He had walked out of the courtroom.
How long after he walked out of the courtroom did you report it?
Within probably 2 minutes, if even that,
To whom?
to the police officer passing by.
Which police officer? Is that officer here today?
Yes,
Okay, and that's who you reported it to?
yes.
That interaction, and if you look back on the right-hand side where the gentleman seated in the black shirt is, you're saying that's where you were sitting.
Yes,
When Mr. Buckner came down the aisle, you'll notice that the back row is basically a handicap accessible row or a non-handicap accessible row. You see that where it extends out?
yes.
How close was Mr. Buckner to you when he's making these comments?
He was past where the gentleman is sitting with the black sweatshirt, and he was in between that row and the woman sitting right behind him. And he leaned back and
And he leaned back.
he was, you know, yeah, turned his head back and spoke to me.
So he's, because that's a little bit different than what you told me before, because you're saying that he was where the gentleman seated in the black
Right.
is, he was past him toward the door.
No, right, there's right where he's sitting, right there, at that spot, right there. It's like there's a spot, you know, where you, not where you would enter, but where would be if you're standing beside. So closer towards the opening of the back row.
So he's standing closest to the opening of the back row.
Right, but he's beside where the gentleman is with the black sweatshirt. And that's where I was.
But so he's over on that side of the courtroom?
Yes,
So ma'am, are you telling me he's no longer in the middle aisle?
no, he crossed from the middle aisle to over to stand closer towards the right-hand side. He's no longer in the middle. He's standing like as if you're having a one-on-one private conversation with somebody.
And how loud were these comments you say he was making?
They were not very, I mean, other people were walking out of the courtroom. I could hear them, and it's not like he was screaming them. They were, I mean, they were normal voices.
When you testified in the previous matter, was there a victim's advocate assigned to you?
Yes, there was a victim's advocate.
Okay, so after you testified, did you talk to that victim's advocate?
No. They asked me to just go sit into the courtroom.
I want to go back, ma'am. At the time that you say Mr. Buckner got up, what's on the screens in the courtroom?
The screen was still on to where you could see where the judge was sitting. And then she called for a conference. And then the screen went blank. And then the screen went back up to where you could see where the judge was sitting. And then she called for a recess.
And then what happened to the screen when she called for a recess?
And then the screen went blank. And said, you know, right, it didn't show any pictures, didn't show any people anymore.
Prior to the judge taking recess, was it Mr. Buckner's other case that was being heard, the case that you were there for?
That case had been heard, and then honestly, I know that case was heard, there was a witness, but I think he was sitting out in the galley, and I think that they had started to call for another case. Because I don't think that.
Had your case that you were there on, had it concluded at that point?
Yes, because he was sitting out in the galley.
Okay. So then my question is that case had concluded,
Yes.
the judge had made her ruling,
No, she had asked for some more information, and they had set it aside for a minute and was gonna call it back up.
and so had they called another case,
Yes,
was Mr. Buckner's attorney on that case?
no, he was sitting on the left side, where the gentleman is, behind his lawyer right now where the glass is.
So he had moved back to the chair.
Yes,
But during Mr. Buckner's case, he was at the table with Mr. Buckner.
yes,
From that period in time, that case ending until the judge took a recess, approximately how much time was there? Mr. Buckner, you said was in that first row, right?
yes,
How far into that first row was he?
like right on the end.
So he's right on the end, seated where I guess the young lady in the pink would be.
Yes, hi. I'm sorry.
Sorry to use the people as props, but that's where he was sitting?
Yes,
Okay, so he's sitting right behind his attorney.
yes,
Okay. And then at some point he gets up
yes.
and walks back. Were you the only witness that had testified in that previous case?
No, it was me and one police officer,
Okay.
but I was the only.
Where was the police officer that testified?
He was sitting over, on the right-hand side where the gentleman is with the glasses.
Did he testify before or after you?
After me,
He testified after you.
yes.
Was there another witness then?
They stopped because the judge asked for information. So they were pausing it to see if they could collect the information that was needed to proceed with the case.
So just so I'm clear, you were the first witness to testify, right?
Yes,
The next witness was a police officer.
yes,
And all during that time, Mr. Buckner is at the table where approximately where he is right now.
yes,
Then at some point, there's a break. Mr. Buckner leaves the table and
yes,
is seated in basically the first seat in the first row behind defense counsel.
yes,
Then another case is called,
yes.
right? And was it the attorneys? Was it the attorneys on that next case? Was that who the judge was talking to?
Yes. I don't know if it was I mean, it was someone from the state and then someone representing that person. So yes, that's who the judge was talking to.
They were the attorneys on the next case.
Yes,
Okay, and the judge spoke with them.
yes.
As the judge is speaking with them, what do you hear in the courtroom?
The noise coming from the speaker and
What noise?
whatever that noise is. I don't know how to describe it,
Okay,
but just so we can't hear what's being said up here at the bench.
okay, so you hear that.
Yes,
At the point that you hear that, where is Mr. Buckner?
still seated.
Okay. The judge then leaves that session, gets up to walk out.
Right, but the screens turned back. When they went back towards their tables, the screens went back to where you could see the judge. And then they called recess.
All right. At the point that they call recess, where is Mr. Buckner?
That's when he stands up, goes towards the middle of it, and then there's two people. He goes, and then that's when he stops. There's two people getting out like in the next row.
How many people were behind Mr. Buckner in the gallop?
Honestly, I don't know. I mean,
How many people were in, was there a person sitting behind you?
I don't think so.
Was there a person next to you?
No.
Was there a person in front of you? Which would have been in the second aisle?
I don't. If there was, I think.
Didn't ask that. Do you know whether or not, okay, do you know whether there was a person 2 aisles up?
Yes. that
Who
a
was-
police officer.
And how far over was the police officer? You're saying where the gentleman that just sat down in the blue tie would be? Mr. Warren
No,
Green, that's you.
further over. He's probably where the other officer is, if not closer towards.
So
the wall.
he's further over toward the wall.
Yes.
Is there anybody else in that row that you recall?
No.
Is there any, so where you are, you're saying there's nobody in your row?
Not that I remember, but I'm not that I remember.
Behind you, you're indicating that there's nobody behind you in that row.
Not that I remember.
In front of you, the row would be directly in front of you. There's nobody in that row that you recall.
Not in front of me, there was someone down.
There was what?
There was someone down closer towards like where the gentleman is with the blue tie. There was two people right there.
There were two people right there?
Yeah. They weren't towards the edge, they were like in the middle down.
When Mr. Buckner allegedly makes those comments, do they turn around?
I was not paying attention. I just put my head down and just let it happen.
Council, I know, council approach briefly. All right, let's go get that. So what I'm gonna do in this case is, and I talked with council, I'm gonna take a brief break. Get some information, get it to council. And then continue the hearing after that.
May this witness be excused or is the court obviously appropriate if the court wants to inquire based on reviewing the video?
Yeah, I don't want this witness excused at this point because I may have questions and the video also may give rise to questions from Mr. Johnson. All right. So we'll pause in this case. You may step down, man. And I'll call you back up and court's gonna take a brief recess. And I know people want to talk to me, but court's gonna take.
Mr. Milano and I were hoping to approach.
Sure, yeah, but court take a brief recess.
All rise.
None of that was caught. All right. State of Michigan versus Lawrence Buckner.
Andrew Childers appearing on behalf of the people, Your Honor.
Good afternoon, Kareem Johnson, on behalf of Mr. Buckner.
All right. We had finished that witness. Do people have a motion?
And I guess just for clarification, I don't think we technically finished the witness.
That's true.
So if the court is satisfied, I have no further questions for that witness.
Okay.
No further questions, Your Honor.
All right, very good.
We'll have no further witnesses, the people will rest.
All right, any witnesses for the defense?
No, Your Honor.
All right.
Your Honor, at this time, the people would move to bind the defendant over as charged on the one count of witness intimidation based on the testimony of our one witness. Obviously, the court has provided both myself and Mr. Johnson copies of the video. Because our county issued laptops don't have CD discs, wasn't able to watch it myself, but I know the court has watched it and I trust the court's judgment in reviewing and will respect the court's decision in that. And so, thank you.
All right. Stretch.
Your Honor, for the testimony, reasons stated on the record through cross-examination and the video that I asked to be admitted as defense exhibit A, I'd ask the court to not bind this matter over.
All right. The court will admit without objection, exhibit A. In this matter, the court was very specific in questioning Ms. Hudson with regard to where she was at particular times and the like, to try to get a sense and feeling as to where Mr. Buckner would have been at any given time. The long and short of it is, when I review the video, it is clear Mr. Buckner is not seated in the first seat. He's actually seated in the second row back. And he's sitting there. We can pick up Mr. Buckner, and I'm looking at it. When I time what portions of the video, well, let me make this clear. There are points at which, when the court goes in recess, there is no video. So in looking at it, the best the court can as to the timing of when the events would have occurred, it is clear we see Mr. Buckner in the courtroom at a particular point. No doubt. He's in that second row, sitting there. He's second row, basically second seat in. At the point at which Ms. Hudson indicates that this occurred, Mr. Buckner is not in the courtroom. And that doesn't mean that it may not have occurred at another point. However, the testimony that I have in this case, it couldn't have happened. Mr. Buckner would not have been in the courtroom at that point in time. So with that finding in the court having reviewed that, the court's going to find that there's no probable cause to bind this defendant over on this charge. These charges are dismissed. Thank you. You don't want to take it and keep it?
No, sir.
Yes. Go over. It'll be entered in the system. We'll call over and make sure that, just get over to community corrections.
I got to go to the other courthouse, and I gotta be there too, so I can just walk across the street.
To do what?
Tether off.
Yeah, you can go over to community corrections. All right. If they give you a problem, tell them to call over to my court and we'll let them know. All right, thank you. For Mills. While we're bringing that out, let me have their case, Slandy's case, and the 11 o'clock.
Yes, I'm sorry.
I told them I'd call them. Hang on one thing. Court does call the case of the people versus Jillian and Kerry.
After one of the people.
Good morning, Your Honor. Michael Bellotta on behalf of Jillian Kerry, who's present to be in court.
In this matter, record shooters like that a bench conference in this case, so.
That's correct, Your Honor. We spoke at length in chambers about this case and its potential alternative resolutions thereof. So we are requesting an adjournment to June 17th to allow for a time to explore those potential alternatives, as well as to have hopefully sufficient time to have expert witness Kevin Parvis testify.
Yes, that's correct, Your Honor.
All right. I will adjourn the preliminary examination then to June 17th, 2025. That's at 12 noon. All right.
Yes,
on that day.
thank you, Your Honor.
All right, thank you. Bond will continue. Thank you.
Yeah.
Court calls the case of the people versus 5A Mills, 3 cases.
Andrew Childers appearing on behalf of the people.
Good afternoon, Your Honor. Edward Bassan, P71061, on behalf of Mr. Tavay Mills, coming to the podium. Mr. Mills, please state your name for the record.
These are all going to be waivers.
That's correct, Judge.
All right. Mr. Mills, it's correct that you're waiving your right to have a preliminary examination in these matters?
Yes, sir.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed. You understand that?
Yes, sir.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution of these matters.
Yes, sir.
People also waive their right.
Yes, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on all the felony counts with the misdemeanors following. Counsel, you acknowledge receipt of the information.
I do acknowledge receipt of the information, Your Honor.
You waive their reading.
And we do waive a formal reading, Your Honor, this time.
And your client stands mute to this.
And it stands mute, Judge, yes.
All right. Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial in these matters will be set.
June 2nd at 1:30 PM with Judge Simpson.
June 2nd, 2025, 1:30, Judge Hamud.
And Judge, I know we just did waive the exam, Judge, but may I briefly address mine, Judge?
You may. Go.
So my client has been in custody since the arrest in this particular matter. I understand that these are serious charges, Judge, but I would also note that my client technically does not have a extensive or criminal history, Judge. His family is in court today. His bond right now is $500,000. Your Honor, I'm asking for a significant bond reduction. He's been unable to post bond. He was working prior to being incarcerated, Judge. His employment is definitely in jeopardy. Again, Judge, I know one of the charges is a capital offense. But Your Honor, I'm asking the court to at least consider, if possible, Judge, a $100,000 bond in this particular case, Judge, as opposed to $500,000. I believe that that's still a significant bond to post. If he's able to.
How much did you say?
I'm asking for at least $100,000 as opposed to $500,000.
All right. I'm sorry, I interrupted.
Oh, and so Judge, I just think that that's still a significant bond to post if he's able to post it. But Judge, $500,000 is unattainable at this time, and I also believe that at this time it's excessive given the circumstances, John.
Yeah, the people respectfully request that the bond remains currently set. The most troubling is that there are two, there's an armed robbery, which is a capital offense that people were able to proceed today. We brought in the victim, the Marine Corps from North Carolina. He's present in the courtroom. So that is obviously a capital offense. It did involve in that instance, the defendant in possession of a firearm. The oldest case involved a LawNet investigation. It subsequently conducted a search warrant. The defendant was ultimately found in possession of distribution quantities of methamphetamine, firearms, as well as 3D printers, items used to make what are commonly called ghost guns, as well as Glock switches to modify the guns. And then when the police went to arrest him on the older warrant, and this was back about 6 weeks ago, the defendant attempted to flee, was in his vehicle, involved in a pursuit involving both the state police as well as Pittsfield Township Police Department, and was again found in possession of a Glock with an extended magazine and more controlled substances. And the search in that yielded other items associated with the modification of firearms to make ghost guns. All of that is both very troubling from a community safety standpoint, as well as the defendant's potential posing a flight risk. So I would ask that bond remains currently set.
Anything else?
Judge, even if the court would impose a tether, Your Honor, or house arrest, just the opportunity to at least post a bond in this case, the $500,000, it's excessive. And again, Judge, I think even with everything the prosecutor just mentioned, I think $100,000 cash bond is still a significant bond to post, and gives him a huge financial stake in his bond that he wouldn't not comply or be a danger to the community or be a safety risk in any way, shape, or form, Judge.
Well, I would consider the defendant to be a safety risk given at least the allegations that are contained in the as represented by the people in this case. I think that given all of the circumstances, this bond is set appropriately. I will deny the request for a bond modification in this case. You can take it up before Judge Wood.
All right, thank you, Judge.
All right, thank you. Court calls case of the people versus Julian Tabbron.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Tabbron. Mr. Tabbron, state your name. Julian Tabbron.
All right. I have in this case a plea form that indicates that the defendant will be pleading no contest to An added count 4 of larceny, 200 to 1,000, the 1-year offense. And also an added count 5 of breaking and entering illegal entry, a 90-day offense. Upon a successful guilty plea to counts or no contest pleas to counts 4 and 5, counts 1, 2, and 3 would then be dismissed. That's the court's full understanding of the agreement.
It's our full understanding, Your Honor.
Yes, Your Honor.
All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give to be the truth, nothing but the truth, so help you God?
Yes.
State your name.
Julian, Tabbron.
Put your hand down. Sir, it is this court's understanding that you're going to plead no contest to 2 charges. Is that your understanding?
Yes.
First of all, it's court's understanding you're going to plead no contest to the charge of larceny, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
The other charge is the charge of breaking and entering illegal entry. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
2 things about it. I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
Mr. Warren Green, the basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of larceny, 200 to 1,000, how do you plead?
No contest.
To the charge of breaking and entering, how do you plead?
No contest.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form.
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No. No, no.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce?
No, Your Honor.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 25395. Any objection to the court having reviewed that report?
None from the defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt of this offense. Counsel, have I complied with the court rule and would it be proper to accept this defendant's plea?
Yes, Your Honor. There is an additional agreement that I failed to mention earlier. As it relates to restitution, the defense would stipulate to restitution up to the amount of $7,030. Your Honor, there's outstanding property that is going to be returned. We have agreed with the prosecution that property will be returned to the Pittsfield Police Department so that it can make its way back to the owner. And restitution may reduce from that point, but at this point we stipulate up to the $7,030.
That's a correct statement.
Yes, sir.
All right, just since it's coming to me, I just want to make sure I understand this. The maximum amount is the $730. $7,030. As property is returned, that somehow is going to be evaluated and it will come off of that amount.
The laptop, if it's returned, would lower that.
Pardon?
I said if the laptop is returned, it would lower that.
The laptop is valued at about $1,000, Your Honor, so we anticipate that the people's request will modify to $6,030.
Got it. Okay, so it will not, okay. I just want to make sure I'm clear. It will not go below $6,030, but it won't go higher than the $7,030.
That's our understanding, Your Honor.
With that, all right, so let me. Okay, have I complied with the court ruling?
Yeah.
The defense is satisfied.
Court will accept the defendant's no contest pleas. Counts 4 and 5, counts 1, 2, and 3 are dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be
June 11th.
June 11th, 2025, 9 a.m. That's before me. Bond in this matter will continue. Thank you. All right, Mr. Tabbron, on your way out of the courthouse, on the left-hand side will be my probation department. You can stop in there to start the process. All right?
Okay.
Thank you.
Thank you, Your Honor.
You know what it is. The cameras, yeah, it's gonna have to be flatter somehow, but the problem is that the cameras at the top, not the side.
So my understanding is we're down to the last 3 defendants and we're holding on all.
Holding on all of them. It's his phone.
He's part of the problem.
Okay. All right. Thought I'd ask. Okay, who else is?
So this is Ms. Senda and Mr. Bird. We also have Ms. Douglas. The other 2, Ms. Douglas and Mr. Brown. And then,
So Miss Douglas and Mr. Brown?
yes.
Oh, that's gonna be funny. No, I'm kidding. All right, well, who's,
And then Ms. Douglas and Mr. Warren.
seems to be a common problem here, Miss Douglas. No. All right, let's,
Mr. Bird.
is Miss Senda, oh, there she is. All right, let's do that. Get counsel out. How many witnesses?
Will be 2 on the RNO file, 1 on the home invasion.
Got it. Court does call the cases of the people raised Devin Gibson.
Ally's on behalf of the chief, Your Honor.
Yes, Your Honor, please, Your Honor, report again. Brandon Bird on behalf of Devin Gibson. Gibson, can you please state your full name for the record? Devin Gibson.
All right, thank you. All right, there are 2 cases here, set for preliminary examination. We're ready to proceed.
Yes, Your Honor. And at this time, the people will be withdrawing their motions for forfeiture by wrongdoing and would be ready to proceed.
All right, very good.
I'm ready to proceed, Your Honor. I do think it's a little preliminary matter that you might want to discuss before taking the record. Won't have, the only complaining witnesses that we have is the police. And the people did make me aware that they were trying to introduce a couple 911 calls. So I believe.
Could we approach, Your Honor?
911 calls on what?
Could we approach, Your Honor?
Counsel, you may want to, while you're talking to your client, press the button on that and you got to hold it down because it's got to be green so we can't hear you.
Right,
You ready?
I still relate to the 911 calls in.
All right, very good. All right. Ready to proceed on this? You may proceed.
Thank you, Your Honor. We start with the case. It's 1110.
Yes, sir. Yes, ma'am.
Thank you, Your Honor. The people would first call Deputy Gerwig to the stand, Your Honor.
Sir, please come forward and be sworn.
You take a seat, raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so. Thanks, spell your first and last name for the record, please.
Deputy Brian, you're a liar.
Good afternoon. Deputy Gerwig, what do you do for a living? And how long have you been employed there?
3 years this year.
And I'd like to direct your attention to March 14th of 2025. Were you working that day? What shift? And were you in a marked patrol car? And were you in uniform? And on that date, were you dispatched to the area of 8517 Cargo Drive? And is that in Ypsilanti, Washtenaw County, Michigan?
Yep.
And what was the nature of that dispatch?
It came out as a domestic incident. Caller was third party, was the father of a female, saying that his daughter and her boyfriend were getting into the apartment.
Okay. And did you come into contact with anyone on scene? Who?
The caller, well, I identify his caller as, just print off.
Okay. And how did he appear to you?
He was upset, visually upset. He did have blood on his forearm.
Okay. And did he want to report an incident to you? And when did this incident occur in relation to the statement he gave to you?
Just moments before, probably 5 to 10.
Okay.
Possibly.
And was there anyone else in the residence at this time?
At the time.
Okay. And you said a 911 call was placed?
Correct.
And do you recognize this? And what's contained on this flash drive? And did you review the contents of the flash drive before this hearing? Okay. And did you recognize a voice on that call? Whose voice was it? Your Honor, the people would move to admit people's proposed exhibit 1.
Any objection or what, or I think by stipulation you're. Okay. All right. Exhibit 1 is admitted.
Thank you, Your Honor.
Washtenaw.
Can I plug it in?
Yep.
Okay. Oh, yeah.
And what's happening?
I think you should know.
I don't you want to phone up with your daughter? What's going on with your daughter?
Name to me.
Okay, is it an apartment over there or is that a house?
No, that's the address, townhouse.
Okay, and when you say she's into it, is it somebody arguing?
Yes, yes.
Who's your daughter arguing?
A boyfriend. Yes, I'm 7 years old. One of them, because I'm running all over me.
Okay, and hold on. Has somebody been physically assaulted?
Hold on.
They assaulted each other?
Yes, ma'am.
And do they need an ambulance?
No, they can't get me to the stuff out of my house.
Okay.
Give me that dog. Come here. Hold on. Come on. No. Come on. Come on, boy.
Has anybody been seeing you on the street today?
Not right now. I will.
What's your name?
My name is fun.
We've got the phone in, okay?
Thank
Where
you.
are they now?
Thank you.
Where are they now?
Come on.
What is the AOC?
Oh, thank you.
How do you spell that last name? Almost getting them out of the way. Let it stay. You try my camera. If you don't try to do it, come on. If you don't do it, come on. Come on. Come on. Let's go. Come on, let's get out there. Come on, come on. Hold up, come on. Very Gibson, you said. Okay. Stop that. I just spell that last name for me. You gotta be. You gotta be. That's what I mean. Gibson. But. What's his first name? Judge. Spell that for me. He's always. We don't know how old he is. 18 months from now. Is he a white male, black male, Asian? What he picked up fire, she heard it on the phone. Say that again? He picked up fire, and she heard it on the phone. She was not that way. But you need Julian, because when you have a call, I told them, here you go. What, are they on foot or do they have a car? They're in the car. What kind of car? It's a brown house. Oh, the dogs are on foot? Yes. What's he wearing? Black shoes, black things, and black and white shoes. Black and white shoes? Yes. And she left with him? Yes, as soon as you all time, I can do this. And when did she with it? Blue jeans, a gray shirt. Gray t-shirt. Gray t-shirt. What's on with this time? And she had a lot of manipulation. Her name? Mr. Prince. Spell that last part. P-R-I-E-T-E. Okay. With him, do you know which way they headed or where they're going? I can't get the dog. So, hopefully, the dog will be here. Come back, I'll be in the office. You will lock up the dog before police get there. I'll just do that. Okay. I just can't do it anymore. Yeah, go back to the dog. He can come in. I'm just thinking, I can't do it. I can't do it. He's don't make a mistake. I can't do it. Do you want us to have answers for your daughter? You've done that. Because pick her up, and she fell like that. They come back or they change their before they get their like the total for their
So going back, you said Lucius wanted to report an incident. What incident did he want to report?
The assault between his daughter and Devin.
And what did he say happened?
So then they're on side around her
I'm here to say.
In your it's a present sense impression of what he just saw happen after police got there.
Better go loud in. Go ahead.
So he reported, what did he want to report?
An assault
And what did he say happened?
Devin, which is his daughter, was sent to the boyfriend, picked her up and slammed her on the head in the apartment.
And did he say anything else happened?
That they got into it, that he was, he tried to break them up and
And did he say what happened to Lucinda after she was slammed to the floor?
said she lost, consciousness, she was just laying there.
Okay. And when you arrived at 8517 Cargo Drive, did you take any photos of the scene? Your Honor, may I approach the witness of people's proposed exhibits? I guess I could change these. 2 through 4.
Yes, you may. Let me just ask this, officer. When you arrived there, who were you speaking with?
On scene, sir.
Pardon?
I was talking to the father, Devin's girlfriend's father. Yes.
All right.
The person I called.
And how did he appear at the time that you?
He was distraught, upset. Trying to tell us what was going on. He had some, what appeared to be blood on his arms.
All right, and that was approximately, I think you said 5 to 10 minutes after the incident had occurred. All right. So just so the record is clear, I'm allowing it either in the present sense impression or as an excited utterance, and that he was under the stress of the situation at the time. So go ahead, Coach.
And may I approach the witness?
You may.
And what did I just hand you?
Picture of the scene of the residence that I took.
And are these a fair and accurate representation of the scene as you observed it on March 14th?
Correct.
Your Honor, the people moved to admit exhibits 2 through 4.
Any objection or voir dire?
No objection.
Exhibits 2 through 4, 2, 3, and 4?
Correct, Your Honor.
2, 3, and 4 are admitted.
And may we publish them to the court, Your Honor?
Yes, sir. Thank you, sir. Go ahead.
And do you know Devin Gibson? Is he in the courtroom today?
Yeah.
Can you briefly describe where he's sitting and something he's wearing?
Sitting left, to the right of you, wearing a horn.
And Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Record shows so reflects without objection.
So during that same shift, at some point, did you find yourself at 8695 Spinnaker Way? And how did you come to be at that address?
A separate caller, in no relation to the original call we were on, saying that there's a male and female in the locker room that's arguing.
Okay. And what happened when you got to that address?
We made contact with later that Devin and Washtenaw.
Okay. And did you interact with Devin when you arrived on scene? And did additional deputies arrive on scene? What other deputies?
Deputy Russell, Sergeant Howe, Deputy Hill.
Okay. And what interaction did you have with the defendant when you arrived?
He was kind of educated. He was in the line with, who was active.
Okay. And did you take any action toward the defendant at this point? What action did you take?
And it was an attempt to detain him pending further investigation.
Okay. And at this time, were you wearing a department issued body worn camera?
Yeah.
And was it activated in recording? If I get one moment, Your Honor.
Yes.
And do you recognize this?
Yes.
What is this?
This,
And is this a fair and accurate representation of what you saw that day?
yes.
Your Honor, the people would move to admit people's proposed exhibits. It's 2 clips from the body camera. I believe 5 and 6.
Any objection or voir dire?
No objection.
Exhibits 5 and 6 are admitted.
Thank you, Your Honor. May we publish to the court?
Yes.
So after you arrested the defendant, what did you do next? And then what happened next?
He began to kick the back passenger door.
Where were you taking him once he was put in the patrol car? Okay, and so what happened when he was being transported?
He kept kicking the back window. Once he kept asking him what his charges were gonna be. We advised him that one of the charges was gonna be property from the vehicle because he kicked you on the scene of Spinnaker. He kicked the door so hard, he bent the door off his frame. Once he was advised of that, he said that if he's going to jail for damaging property, he's gonna damage property and kick out the back window.
Okay, and at this time that this occurred, was your in-car camera on at the time? And it was on and activated? And do you recognize this video? What is this?
Our cameras of the years.
And is this a fair and accurate representation of the video that your in-car camera recorded of your patrol vehicle?
Yes.
Your Honor, people would move to admit people's proposed exhibits. Sorry, I think I lost count. Were we at
We'd be at 7.
7, 8, 9, 10, 11, and 12?
Okay.
And these would also be in clips, Your Honor.
7, 8, 9, 10, 11, and 12 are.
Thank you, Your Honor.
Wash our face off, nigga, and get the fuck up, nigga. That shit weird, bro. That's weird as fuck, bro. Y'all gotta clean that shit. I hope that shit get on with you, I think, too. Real shit. That shit weird as fuck, bro. I just walked in, put a whole gun on my face, bro. Y'all wanna take me to jail for a fucking NDOP, bro? Y'all said for one of them, so for domestic violence, for one of them, resisting arrest. So you wanna, I don't know, y'all dirty as fuck, bro. And you try to bitch, you chick, bitch. I know why you don't like me, because you used to cut off my off, and you're a fucking chick, nigga. You're a fucking chick, nigga. You're weird, nigga. But you was the main one twisting my arm and doing that lame ass shit. But y'all don't be sick as fuck when I'm out tomorrow, all that shit, bro. Without that ass fucking wrong, bro. Put it on fucking deal, bro. That's it, right in the jail, bro. And I gotta, yeah. Get the fuck away, I'm fucked up. Dog, weird ass shit, bro. I'm still putting on my leg, and I got no medical shit. Oh. For NDOP? I'll say, do I got NDOP on it? So I got it, right? Yes or no? NDOP? Yes, I told somebody to break out your window there, right? Right? I'll jump. See, why y'all wanna do stuff like that to me, bro? Why y'all wanna do? I'm gonna jump out. I'm jumping out. I'm jumping out. Yeah, nigga. Yeah, nigga. Why y'all wanna do that to me? Why y'all wanna do that to me, though? Why y'all wanna do that? I was way out. Yeah, nigga. Y'all weird as fuck.
And your apologies, it would be, the last one would be exhibit 11, not 12.
11.
Correct. So after this, was your patrol car damaged?
Yes.
Did you get an estimate for the cost of those damages? About how much was that estimate? And did you provide this estimate to the people? Your Honor, may I approach the witness of People's Proposed Exhibit 12?
12. Any objection to 12?
Oh, Judge.
12 is admitted.
And may we publish that to the court, Your Honor?
Yes, sir. God, you're calling up.
Your Honor, may I have a moment?
You may.
Thank you. Nothing further from the people.
Cross-examination.
Officer Gerwig,
Yes, sir.
you said Mr. Printup told you that what did Mr. Printup tell you again?
On scene or?
When you came on the scene to talk to him?
That his daughter, sorry, the names are real close together. His daughter Lucinda and her boyfriend Devin got into us all.
You said he told you they picked you up and slammed him too, right? Why didn't you put that in your report? Would you like to refresh your memory?
I'm not in there.
You say
I said, if you're asking me about it, I take it's probably not in there.
it's not. So why didn't you put it in your report if that's what he told you? That seems like a pretty big detail.
He told this. Or he talked to my partner.
So basically, what he told you was they both were fighting, correct?
Right.
And he never told you who started it, correct? He never, he never said, was my client trying to protect himself or was he the aggressor, correct? You knew there was blood, but you didn't know where it came from. He never said that the blood came from his daughter. But that was the assumption, correct? Now, when you came on the scene where Devin was, how many officers were there already?
The second.
Second.
Not the where his dad was, the one.
Right.
Second call.
Second call.
Everybody that was already showed up on the first one, so. Okay, 4 after me.
It was 4 after you
I believe so.
or 4 before you?
After, well, with him.
With you? Okay, so you were one of the first on the scene? And was Lucinda there when you came?
Which time? Initial?
To arrest Devin?
I believe that was her.
You believe that was her? So you wouldn't know who Lucinda was if you seen?
Not at the first time, no.
Got you.
So after the investigation,
And how many times have you met Lucinda and Lucius? Print up.
my partner has,
How many times have you met them?
have I met him once before?
You say once before?
Possibly, yes.
When's the last time you talked to Mr. Printup, Lucius Printup?
For this,
Before this court date?
I haven't.
You haven't? When was the last time you talked to him before you were on the scene with him? Before you pulled up on the scene to talk to Mr. Lucius to investigate the situation before you went to go arrest Devin? When was the last time that you talked to Mr. Printup? You said once before that, correct?
Correct.
When?
Said I did.
I said when? When was the last time? When was? You don't understand the time? You don't understand the time frame? I'm asking you, you said, this is what I'm trying to get to. How long have you known Mr. Printup? Because you said you remember his voice. You said you would know his voice.
From the phone call and speaking.
From the phone call and speakers. How would you know his voice from the phone call and speakers from something that happened a month ago? How many other people have you arrested?
That's how I know the voice, which I just told you from the scene, I know his voice from phone calls.
So you got that good of a memory?
I want to talk to him and see if hear a phone call, then it would be correct, yes.
Gotcha. But you forgot to put the body slam in the report.
Is that a question or?
I'm sorry, Young. I'm sorry. That was commentary, Young.
Okay, then I don't need it.
I know,
Okay,
and I
get to the next
apologize. I apologize. Now, when you came on the scene, were you all trying to arrest him? Was it a collaborative effort of all the officers there? Yep, to arrest my client.
Or just opinion.
When you did arrest him, was there, right?
Well, kind of resisting us, that yes, all of us did.
Did he assault any officers individually? Did he assault you individually? Did he resist you individually, or were all the officers being resisted? And
Resisted myself and my partner.
so he was resisting the collaborative effort that you all were using to try and arrest him. Would that be a correct, accurate statement? Did he ever assault you? I do understand, he did say a negative comment. He did say a negative comment to you.
About my agent of dissent, that's correct.
He did, and which is reprehensible, but did he ever threaten you because of your agent of dissent?
Oh, my agent of dissent? No, he never threatened.
Did he ever threaten to damage any property you had because of your agent of dissent? So it basically was a statement. Out of my client's anger and the excitement of the situation.
A very derogatory statement. Yes.
No, very derogatory. And I'm not gonna take that fact from you. I'm sorry that happened.
I get what you're saying, yes, there was nothing relation between he's saying he's damaging anything of mine because of my agent dissent. No.
Got you. All right, no further questions, John.
All right, anything else?
I have one moment, Your Honor.
Right.
Just for the people, Your Honor.
All right, you may step down. Thank you. Oh, your next word.
Thank you, Your Honor. People call Deputy Samaha, Your Honor.
Please come forward and be sworn.
Raise your right hand. Solemnly swear to affirm. State spell your first and last name correctly.
First name, Deputy Samaha, spelled Devena, last name spelled Samaha.
Give me that again. I'm sorry.
My last name?
Yes, please.
Sir. Samaha.
That was easy. All right. All right, go ahead.
Thank you, Your Honor. Deputy Samaha, what do you do for a living?
I work in the Washtenaw County Sheriff.
And how long have you been employed there?
Over 2 years
Okay, I'd like to direct your attention to March 14th of 2025. On that date, were you working?
I was.
What shift?
The noon shift.
And were you in a marked patrol car that day?
I was.
Were you in uniform?
I was.
Okay. And during that shift, did you find yourself at 8695 Spinnaker Way?
I did.
And how did you come to be at that address?
The call came out and deputies Hill and Berwick were responding to that address. And I started making my way over there just to back them up.
Okay. And did you come into contact with anyone at that address?
Not at that address. Deputy Berwick at the time gave us the description of the two, male and female, and we went to BOL, which pretty much looked for them in the area.
Okay. And did you find anyone matching those descriptions?
I did.
Okay. And when you went to 8695 Spinnaker Way, was there anyone you came into contact with there? Okay. And when you say Lucinda, who's Lucinda?
So initially when I arrived there, she was, from my knowledge, the victim at the time. She was bleeding from her finger. I had no context whatsoever at that time. I just made my way back to the laundry room where she was, and she was like washing her hands.
Okay. And how did she appear to you?
She was definitely in distress, hysterical, kind of all over the place.
Okay. And what did you do after coming into contact with Lucinda?
I escorted her out of the building and towards my patrol vehicle.
Okay, and when you got to your patrol vehicle, how did she appear then?
She was bleeding from the finger, so we tried to clean her up. Essentially, she was able to carry her own body weight. Then she just kind of started going in and out of consciousness on me. At that time, I had her sit in the back of my patrol vehicle. I had my door open. She was not coherent, was not able to give me any statement. And she, again, just could not carry her own body weight. So at that time, my priority was to stabilize her head so she wouldn't hit it.
Okay, and what happened after that?
We requested HVA and they arrived and they took over.
Okay. Nothing further for this witness, Your Honor.
Cross-examination.
I'm sorry, so, how do I pronounce your name? So I'll get it. Samaha. Nice to meet you.
SAMA. Okay. I got that. Go ahead.
Yeah, oh, no, I was about to ask that question. I wasn't about to ask that question. Now, how many officers were there by the time you got to the scene?
When I arrived, there were 4, possibly 5, if I remember correctly.
Got you. And okay. Did you interact with both Mr. Gibson and Ms. Printup or just Ms. Printup?
Just Ms. Printup.
You never seen Mr. Gibson put his hands on Ms. Printup?
No, sir. So I arrived after the fact. I was not there, no.
And you say she was in a hysterical state?
Correct.
Did she ever tell you that my client put his hands on you?
She did not give me a statement, no, sir.
She didn't give you any statement? Did she tell you that he didn't do it? He didn't do anything?
So from what I can recall properly, she did not give me any statement at all. Again, she was kind of in that state of going in and out of consciousness, so I just stopped questioning. We didn't get any further, no statement, no questioning. It was just kind of making sure that she did not hit her head at that point.
Did you see any injuries on her head?
Not on her head, no.
The only injury you seen was on her finger?
She was.
So, is it safe to say you don't know why she was feeling the way she felt, or?
That is correct. I could not tell you why she felt the way that she felt.
All right, thank you. No further questions, John.
Can you redirect?
No, Your Honor.
All right. Thank you, Devin.
Yeah.
No further witnesses for the people, Your Honor.
Right.
Witnesses, John.
All right. Go ahead.
Next one.
Well, what do you want to do?
Well,
Well, what do you tell me? No, you don't tell me. Go ahead. Do the next case.
Do the next case?
Want to do the bind over on this one?
Please.
Go ahead.
Okay, Your Honor, at this time, the people would motion for bind over. The court heard testimony from Deputy Gerwig saying that Lucius reported an incident where the defendant slammed the victim onto the ground, making her hit her head and lose consciousness. The court further heard from Deputy Straw that after this event, she had a cut and also was unable to hold up her own body, able to lift her head, was incoherent from this injury that she sustained from the defendant. The court further saw body cam footage as well as the in-car footage of the defendant resisting the arrest of the officers, refusing to put his hands behind his back, 10 seconds away, refusing to walk to the car, fighting with officers while he was being arrested. The court also saw in the car the defendant spit on the car multiple times, as well as kicking out the window and causing extensive damage, over $2,000 to that patrol car. So I believe we have met the burden of probable cause in this case to ask the court to bind over.
Response.
Respectfully, Your Honor, when it comes to the assault with intent to great bodily harm, domestic violence, my client, first of all, we don't have any witness to witness it. The only thing we have is tape and the officer statements, when the officer statement and the 911 tape in which you could hear him clearly say they both are fighting. We don't know who was the aggressor in that situation. Unfortunately, I can't cross-examine anybody to find out what was going on. We do hear on the phone where he said, he picked her up, my client, picking his print up and slammed it, but we don't know what that means. I can't cross-examine him and say, how was that? Was she trying to hit him? Did he grab her? And that happened. Was it in self-defense? We don't have any of that in front of us, you know. Respectfully, when it comes to the resisting obstructing a police officer, I think we got one resisting obstructing for the most part. In Michigan case law, it has to be an individualized attack on each officer when they charge it in different counts. In this case, this was one situation which a group of officers were attempting to arrest my client. It's not like he kicked one officer, punched another officer. It was one big, and I wouldn't even say it was assaulted. It wouldn't even go to the assault part, more the resisting part. He was potentially resisting arrest. He was actually frightened, and I wouldn't even call it resisting arrest. He was just frightened, but if we're gonna call it that, he was frightening arrest from multiple officers at the same time. So I would just say that wouldn't be against four different officers. Is one.
You have that case law?
I do, Jan. I'm glad you asked.
All right.
Give me 1 second. If you go to people rewards, 314 mishap,
314 mishap.
399, 2016.
And what's it say?
It says, the holding is multiple counts of resisting obstructing where appropriate, where the defendant committed distinct acts against multiple officers. Let me see. First two convictions where the conduct was one continuous act that affected multiple officers.
Sounds to me like you said it's appropriate then to charge.
It's not appropriate to charge, Donna. And the ethnic intimidation, you really can't do that because with ethnic intimidation, he didn't do it because of Mr. Gerwig.
I think actually Deputy Gerwig, he stated accurately, it would not amount to ethnic intimidation.
Right. Now, it was a horrible thing.
Absolutely reprehensible and hurtful and beyond the pale in terms of what another human being should say, but it may not constitute a crime. You're right.
I agree. So I think we only got about one count of resisting obstruction. Resisting obstruction. At the most, no ethnic intimidation, and we don't have witnesses here in which I could cross-examine anything that was being said. The biggest thing we heard is that they both were fighting. That was consistent. That was consistent in the report from Deputy Gerwig. That was consistent in the statement from off of the 911 call. We did also hear that he picked her up and slammed her. Well, we don't know the reasoning behind that, and we don't know what that means. I'm not able to talk to Mr. Printup and say, did he pick her up because she was hitting on him like this and dropped her? I'm not able to do that, Your Honor. So respectfully, we're asking to not bind over all the charges, but I would understand if there is one resisting obstruction charge.
One?
One.
Okay.
One. I understand in the malicious destruction.
At what point are we talking about the resisting obstructor? Are we talking about in the hallway where at least I saw 3 distinct incidents? Are we talking about going down the stairway, which once at the bottom I saw another incident? And or are we talking about at the car when he refused to follow the officer's instructions?
I would call that.
Which resisting and obstructing would you say is the one?
I would say, well, I can't say. I say if anything. That's why I put if anything. But I don't see 3 different distinct acts, Your Honor. I see it all as one continuous act of the police trying to arrest him and put him in the car. That's how I see it. Once they got the cuffs on him, they got him up. He walked down.
Okay. Yeah. I see how you may be looking at it. I think you're wrong, but okay.
Right. That's how I'm looking at it. Respectfully, that's what we asked, you know.
All right. Anything, I don't need any additional argument, but is there an argument from the people?
Nothing but people are-
All right, the court after all of the evidence in the case and seeing the exhibits and the videos would find that the people have indeed sustained their burden as to the majority of these counts. As it regards count one, the assault with the intent to commit great bodily harm, less than murder, not only by the statements, but also when Deputy Smaha shows up afterwards, her interaction with Miss Printup buttresses that case of her getting dropped on her head, because first of all, she has a cut. There's the blood that's in the apartment, but then also, as described by Officer Maha, her inability to carry on a coherent conversation. And as the deputy indicated, she was looking to just stabilize her head. It's obvious that something had occurred given the statements that were made. I think that people could show, and that a reasonable fact finder could conclude that there was an assault with intent to do great bodily harm done on Miss Printup by this defendant. So therefore, the court will bind the defendant over on that charge. Count two, the malicious destruction of fire and police property. I don't think there's should be any dispute. One can watch the video and see definitely that that's exactly what he did. He did almost $2,500, $2,600 worth of damage to that vehicle in his little fit of rage that he went into. With regard to the resisting and obstructing, as contained in counts 3, 4, 5, and 6, the court, while understanding what the defendant is saying, if it were this one event in there, it could be charged as only or properly found to be only one. But when one looks at the video, one can either do this by officer or the separate events that this defendant engaged in as they are trying to take him into custody. As I indicate, you just need to look at the acts of the defendant and what the officers had to do, because there are some officers that aren't even engaged with the initially, but have to then engage, which he then resists, that are happening in that hallway area or that vestibule area. There is then additional resisting and obstructing as he's coming down the stairway, and other officers have to jump in to try to get him to do that, particularly when he gets outside. He is walking after they've had to carry him down. He then goes into another event where he stops moving, and they have to then move the officer. The officers have to move him. They then finally get him to the vehicle. Sitting there, they're trying to get him to just put himself into the vehicle as they have sat him in the doorway, and he is refusing to do that. And then the officers have to re-engage with this defendant to then put him in. So whether it be by officer or whether it be by event, as the court has laid out, I think the charges of resisting and obstructing, and quite frankly, I think that there could be more, but I will bind the defendant over on 4 counts of resisting and obstructing. With regard to, and I've already stated it, with regard to the ethnic intimidation, I think it's one of the most despicable things this defendant could have entered into. Obviously not your finest moment, but also just say shameful as a human being. In particular, shameful is you can roll your eyes all you want, but I'm gonna tell you what, when you can sit there and say that kind of thing, you as a man of color growing up in this country, I don't even know how you get there. Don't know how you get there. But I don't think it fits the crime of ethnic intimidation, and won't bind him over on that charge. The defendant is bound over on counts 1 through 6. You know what? You better check your client. Take him back. Bind him over. We'll call the next case up after you check him. 1 through 6. Counsel, you acknowledge receipt of the information client stands mute to those charges.
Yes, Your Honor.
Been in every way, form, or reading, standing mute. Court will enter a not guilty plea. Pretrial in that matter will be set for
July 17th at 1:30 before Judge Slay.
July 17, 2025, 1:30. Judge Slay. Bond on that matter will continue. My understanding is he's waiving on the other matter.
Yes, Your Honor.
Mr. Gibson, you're waiving your right to a preliminary examination on the other case?
Correct.
And you understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Correct.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Correct.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count 1 with 2 and 3 following. Counsel, you acknowledge receipt of the information, waive its reading.
Yes, Your Honor.
Your client stands mute.
Yes, Your Honor.
Defendant every way form of reading, standing mute. Court will enter a not guilty plea to all 3 counts. Pretrial in that matter will be set for
May 29th at 1:30 before Judge Slay.
May 29, 2025, 1:30, Judge Slay. Bond in that case will continue. Thank you.
Thank you, Your Honor. May I approach to sign the information?
Yes. Got a side note. What's my other waiver so I can get that?
Have a great day.
All right. Bird, you take care. Bird, I didn't know you ever gonna find that case law for me. That's okay. That's okay. I am a patient judge.
I appreciate it too. I had so much to go through because we had another motion.
Yes, I got you. I got you.
So you're patient, Joe?
Wow.
When did that? Alan, did some change?
What do you mean you don't know? Seriously, Alan? Court does call the case of People versus Jance.
Andrew Childers appearing on behalf of people.
And Alex Warren Green on behalf of Jance. Mr. Jance, can you state your name for the court?
James Jance. All right. He's waiving his right.
That's correct, Your Honor. He's executing the form right now. In exchange for his waiver, the people have agreed to reduce the OWI third to an OWI second in circuit court, and have extended a sentencing agreement to no prison.
That's correct.
Mr. Jance, you're waiving your right to a preliminary examination.
Yeah.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes.
All right. People also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on counts 1, 2, and 3 with 4 and 5 following.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute.
Defendant never waived formal reading, standing mute. Excuse me. Court will enter a not guilty plea as to all 5 counts. Pretrial in this matter will be set June 3rd, 2025, 1:30 before Judge Combs.
3 weeks.
Bond will continue. Thank you. I don't know. I don't have a loose information for whatever reason.
I will have.
There wasn't one in that one. I don't know what's happening because that's like the 5th file today where we didn't have them. All right,
Your Honor.
Thank you.
That's fine.
Right, who's on the other side of yours? Childers?
Here.
Okay. Let's call the case of the people versus Chalice McCoy.
Andrew Childers, appearing on behalf of the people.
I'm the Long Brown deputy, called the defender appearing with and on behalf of client Mr. Chalice McCoy.
All right.
Chalice McCoy.
All right, thank you. All right, date and time set for preliminary examination. Ready to proceed, you may call your first witness.
There they are. I'll start with, we'll have Deputy Phillips testify first.
Please come forward and be sworn.
Please raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth. State spell your first and last name for the record.
Chalice, A-L-E-S, Phillips, P-H-I-L-L-I-P-S.
All right, main court.
Sir, how are you currently employed?
I am currently employed with the Washtenaw County Sheriff's Office,
And how long have you worked there?
approximately 5 years.
Were you working in that capacity back on April the 15th of this year, 2025?
I was,
Were you alone or with a partner at the time?
I had a partner,
Who was that?
Devin Goulet.
Directing your attention to, I believe it was kind of mid-morning on that date, April 15th. Were you dispatched in relation to a possible stolen vehicle?
I was,
Okay, tell me about that.
gave me a call, for a reported unit at the hotel located at 1275 South Huron. Myself and my partner initially called and spoke to the complainant who preliminary statement and then advised videos, cameras at the hotel.
Okay, and this, what kind of hotel is this on here?
This is the Marriott.
Okay. Did you and your partner physically respond to that location, or did you just communicate via phone?
We did respond out.
Okay. Did you or your partner make contact with the owner of that vehicle?
We did.
Okay, tell me about that.
She advised that she left her car there.
Two things, Your Honor. One, I'm not offering this for the truth of the matter asserted, but only to explain, in part, to explain what the deputies did. But further, and I'll get to this, permission to use property hearsay is admissible under 1101B8 at preliminary examination, and I do intend to elicit that testimony.
All right, very good. Then I'll overrule the objection with the understanding that it's not offered for the truth of the matter, except to the extent it goes to the issue of permission.
Correct. Thank you. Go ahead, Deputy Phillips.
She advised that she left her car in the parking lot overnight, and when she returned home, the vehicle was not there.
Okay. Did she let you know if anyone had permission to take that vehicle at that time?
No, the relevance of this, I don't, it's my understanding, we're not doing the UDA, right, just the.
Oh, I didn't know that.
Oh. Okay.
What?
I was planning on making sure I can prove all my elements.
Oh, no.
Oh, yeah, come on. I guess. Record should reflect we had a bench conference in this case, and while the testimony Deputy Phillips has started, my understanding is that there was additional evidence that came that is now there that as a result of a search of a phone that is now in the possession or will be in the possession of people that need to be turned over to the defense.
That's correct. And I apologize. I am last minute covering this. The assigned APA became ill and had to excuse herself. And I trust Mr. Brown that he had this conversation with Ms. Douglas earlier in the morning. So I have no problem with that. And I think that based on that new discovery and the fact that we would ultimately likely have to just recall the same witnesses, moving this whole exam to a new date to allow an opportunity to receive and review that discovery maybe makes the most sense.
So what I will do is I'll move to my next available date, which is June 3rd, 2025. 9 a.m. That's before me. All right.
Thank you.
Yeah. All right. Thank you. His bond will continue.
Thank you, Your Honor.